Good morning, and welcome to the July 2021 oral arguments before the Kansas Court of Appeals. My name is Sarah Warner, and I will be the presiding judge today. Before I call this morning's first case, I'd like to spend a few minutes to introduce our panel of distinguished judges. First, Judge Amy Klein joined our court this year, coming from a firm in Wichita. And then Judge Richard Walker has served as a senior judge on our court since 2015, after he retired as a district judge in Newton. And as I mentioned, my name's Sarah Warner. I came and joined the court in 2019 after practicing in Lawrence for several years. In preparation for today's argument, we judges have thoroughly reviewed the parties' briefs and the court record, along with a legal memorandum that has been prepared by a research attorney. So this means that we're familiar with the facts of the case. But because this argument is being streamed online and will be archived as a standalone video, I've asked appellant's attorney to provide a 30-second to 1-minute factual summary as to how we got here and the issues that we're going to be discussing before diving into the argument. This case is scheduled to allow each party 15 minutes for argument, and I, as the presiding judge, will be keeping time, including any rebuttal time that's granted to the appellant. At this time, I call case number 122254 from Reno County, Gabryelle Gilliam, appellee versus Kansas State Fair Board appellant. Will the parties please state their appearances?
MJ Willoughby, Assistant Attorney General for Respondent Appellant, Kansas State Fair.
Your Honor, please. Chris McElgun, representing Gabryelle Gilliam, the appellee in this matter.
Ms. Willoughby, would you like to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes.
5 minutes is granted. Counsel, you may begin your argument.
Thank you, Your Honor. In 2016, the Kansas State Fair, through its management, disqualified 2 of Gabryelle Gilliam's livestock entries to the youth livestock competition in the Kansas State Fair based on 2 violations. One of the violations was that the DNA on Gilliam's prize-winning sheep matched sheep shown at the Wisconsin State Fair the same year. The second ground for disqualification was that there were numerous injection sites observed in the rear legs of the champion sheep. Gilliam sought a meeting before the Joint Committee of the State Fair, and in that meeting, one of the disqualification grounds, the DNA ground, was overturned. The other disqualification ground, the numerous injections and the edema, was affirmed, and that decision went on to the State Fair Board, which affirmed the decision. And from there, Gilliam sought review. So that is our summary. That sort of illustrates in a nutshell the Kansas Youth Livestock Competition is a competition that's not about the winning of it. It is about how you play the game. It is about character. It is about learning through the project. It is about good animal husbandry. It is about integrity, and the integrity of the competition itself and the integrity of the exhibitors. So without that ability to make and enforce agreed to contest rules, including the rules on unethical fitting, the Kansas State Fair cannot ensure the integrity of its competition. And that mission is endangered or possibly completely lost. So that's why the Kansas State Fair, through its management, and Susan Sankey at that time, was disqualifying Gabryelle Gilliam, the 2016 State Fair entry, for unethical fitting. She was protecting the integrity of the State Fair by enforcing these rules, and these rules of competition are found in the record in the Kansas State Fair rules, but also in an International Association of Fairs and Expositions Code of Conduct. Both of those sets of rules.
Counsel, what was the evidence of unethical fitting here? Was it simply the finding of multiple injection sites in the legs?
There were the numerous injection sites in both back legs of the champion lamb. There was substantial edema observed and documented, fluid observed. The veterinarian stated his terms and medical findings, which, and talked about the discoloration of the lamb, the amount of fluid that was observed. And the committee found that the placement of these injections seemed purposeful. The timing also was shortly before the Kansas State Fair competition occurred. And the other thing that stands out that people remarked upon in the joint committee was the absence of a positive drug result, which is not exculpatory, it's rather inculpatory, because if there had been a positive drug result, we would know there was a therapeutic purpose perhaps for the injections, like an antibiotic or something needed for the lamb's health. And so all of that also combined with the absence of any credible explanation from the Gilliams. They asked for a meeting before the joint committee. And although they presented evidence and argument on the other ground for disqualification, the DNA ground, they presented nothing on the injections. They basically just argued that the son of a competitor must have done it while the animal was in the champion barn. So based on that, the State Fair had nothing before it but the obvious evidence of these purposeful injections.
Council, I was looking at the committee's, I believe it was the committee's summary of its findings. And there's a paragraph there where it specifically talks about what kind of a summarization of the evidence and then its conclusion. And within that paragraph, it includes these two findings. Number one, no evidence was presented that indicated any member of the Gilliam family caused any injections to be undertaken. And number two, State Fair staff did not properly secure the animal after the final show and cannot conclusively show the injections did not occur at this time. What are those? Are those findings? And if so, how do we reconcile them with the committee's conclusion?
Well, I would regard them as dicta because whatever they were, and it seemed to be the committee's attempt to basically give the Gilliams, their due for what they were worth. The whole committee process, it showed the committee was very willing to listen to what the Gilliams had to say. But the bottom line, as far as it was irrelevant because under the rules, the exhibitor is solely responsible for the condition of these entries at all times. So they did not have to have knowledge of how the injections occurred. And the truth of it was that no one saw these injections being given. So that's the question. And that was the point they made is, do you have pictures of us doing it? No, we don't. But it was almost the idea that these injections basically speak for themselves in the sense that they were, obvious, numerous, purposely placed, no other explanation, both back legs. The edema would be swelling. Yes, I don't know why those findings are in there. I think they were trying to summarize what was said at the hearing, and certainly the Gilliams were making those points, although the relevance of those points was not clear because it didn't change the decision, and it certainly didn't affect what the Fair Board decided to adopt.
I have a question, if I may, Council. Really two questions having to do with the process. Question number one, isn't it true that the veterinarian who examined the carcass, I guess, basically never put the label unethical fitting on things? That was the board's conclusion or the committee's conclusion after hearing his testimony. Second is, wasn't one of the committee members, and I understand they recused themselves, kind of offering expert advice from the bench as part of the joint committee's efforts on things? Would you respond? And isn't that a problem in and of itself?
Well, No, it's not a problem, but I'll explain. The veterinarian did not use those words, unethical. I declared this lamb unethically fed. No, he didn't say that. He's a medical man and he stated his observations in medical terms. That was a point that was seized upon by appellant and accepted, or appellee and accepted by the district court, but that was error. And for a couple reasons. The rules themselves, under both consequences, where that language comes from, and also interpretation, as well as the code of conduct, decree that management makes the decision on whether there's a rules violation. So here, Susan Sankey is considered management as well as the joint committee. So that was their decision on rules interpretation to make. The other thing I'd say about it is the veterinarian's opinion was a basis, but it wasn't the whole basis. We're supposed to look at the record as a whole, which 249 pages. We're not supposed to take one sentence out of one clause of one document. And also the idea of imperia materia, which I hate to use Latin because I'm not good with it, but that idea about when you're looking at rules and a statute and contract, you look at the entire document and the entire intent. And the intent of those documents that were signed by the Gilliams and agreed to was that management gets to interpret these rules and actually without recourse, which, well, that is what it is. I know it rankles lawyers, and then your point about Jackie, the Secretary of Agriculture. At the joint meeting, the various members, including others, were opining because there was no explanation for these shots for what they were observing, and none given by the Gilliams, who had the burden of coming forward with evidence to overcome the agency's decision. And so they were saying, well, why would you put those in there? So they were all sort of saying, as experts in the agricultural industry and as show experts, show people, this is what we've observed. This is why people might do that. And so people were saying, well, the fact that we didn't find a positive drug residue, is that exonerating or inculpatory? And so that was explained. So a lot of that discussion on that record was their attempts to interpret the rules. And so, as I would not call it expert testimony in that sense, but it was in the sense that these people are all experienced in the agricultural and livestock industry, which most of us are not these days. The district court certainly wasn't. So the issue with this whole approach, which was taken by the appellee and by the district court in error, was basically to parse these findings and try to nitpick at it, which is the kind of thing that Harsay, which is cited in the brief, the Board of County Commissioners, Cherokee County, the racing and gaming case, the Supreme Court says, no, that's not the role of a reviewing court on substantial evidence. It's basically to see, is there evidence in the record as a whole to support the agency's decision, given deference to or presuming the validity of the agency's interpretation, considering the joint committee here's ability to view the veracity of the Gilliams at the meeting, and considering, again, that standard under which, under 77-621, the appellant or the person seeking review there bears the burden. So the district judge basically just switched the burden and said, well, you had to prove that this actually changed the land, but the code of conduct says all the crime of attempt is all you need to show. It's unlawful to attempt that, it's prohibited to attempt that. And also the burden wasn't on the fair at that point. I mean, from the time the initial decision was made, the burden was on the Gilliams to overturn it, the agency decision.
Council, you're coming to the end of or are at the end of your 10 minutes. Are there any other questions from the panel for Ms.
Very
Willoughby?
quickly. Are you still, counsel, are you still pursuing your jurisdictional argument?
Yes, because jurisdiction's never waived, fortunately. So I think we've covered it in the brief, but in the rebuttal time, if you'd like me to address it, I will. So So I thank you, Your Honors, for your time. We will ask that the decision of the State Fair Board to disqualify this entry be affirmed and the district court reversed. And actually, during Mr. Gilliam's time, a good question to ask them would be why they didn't seek review earlier. That's a question I've never heard an answer to.
Counsel?
Your Honor, please, thank you for the opportunity. I'm going to address directly a couple of the questions. I think number one, the findings in the joint committee's decision regarding there was no evidence presented that the Gilliams had any involvement in the injections, and that the fair did not properly secure the lamb after the grand drive are findings. They're part of the decisions. They're facts. They can hardly be dicta, and they go directly to some of the arguments that were presented.
Counsel, I was wondering if you could help me work through the district court decision in this case. So in reviewing that decision, the court found that there is some evidence, or was some evidence, to support the State Fair Board's decision, but that evidence was not substantial. Can you talk me through that reasoning? What did the court mean?
I'd be more than happy to. First, to focus the panel and to be and to acknowledge what the true issue is. That if in the event that you conclude that there is no requirement under the applicable procedures and regulations imposed by the board on participants, if a veterinarian's finding or declaration of unethical fitting is not the standard to be applied, then we have to acknowledge that the board is correct in its arguments. But I think when you go back and look at the general information, the rules that are applicable, they clearly say that in the event the animal is declared by the veterinarian or testing agency to be unethically fitted, the animal will be immediately disqualified and the participant will have to forfeit all the prizes. If we go back and look at the citation, the initial order or finding of disqualification that was issued by Ms. Sankey, the general manager of the fair, we find that is the standard that was in the description of the regulations that were used to judge whether or not Gabryelle's Grand Champion lamb would be disqualified for unethical fitting. And at volume 1 of the record at page 47, for a quick reference, it basically says, in the event that any animal is declared by the veterinarian to be unethically fitted, the animal is disqualified. It's against that backdrop of the standards that the board has established that trigger disqualification. Yes, there are regulations regarding what you can't do, what you can't attempt to do. But what is required in fairness and to preserve the integrity, both for participants and for the board, there has to be something more before a land or a entry is disqualified. And what is that? Under the board's own regulations. And in fact, the one on unethical fitting is on I believe on the first page of the rules. Requires something more. It requires a declaration of unethical fitting, and that is what the Judge Rose was looking at in coming to that conclusion on substantial evidence, because the board really doesn't. in its briefing doesn't really articulate what the right standard is. Yes, substantial evidence. You look at the record as a whole, you don't weigh veracity, and you determine whether or not there's enough evidence to support. But there in 2009, there was an amendment that said that a district court judge is also to look at the record as a whole to see what evidence undermined the conclusion and come to a decision on arbitrary and capricious and substantial evidence. And when you use these regulations in the standard in what was set forth as the basis for disqualification and the requirements of disqualification in the November 10, 2016 disqualification letter, that is what the judge was focused on. And by saying there was some evidence, there was evidence of injection. And my clients never disputed that. They never disputed that. Their testimony was they had no idea how those specific injections came about. And they had no knowledge or information that when the lamb was at the fair, beginning on the September 9th through the slaughter on September 13th, how any type of injections of this type were caused or administered. So we have.
Counsel, I want to just make sure that I understand. Your position is the reason that Judge Rose found that the evidence was not substantial in this case was based on an interpretation of the rules that said that in order for unethical fitting to be a reason for disqualification, there had to be a declaration by a veterinarian that there had been unethical fitting. Is that correct?
That's our position.
Okay. Thank you.
Yeah, and to kind of wrap up that point, and not to belabor it longer than the answer might need to be, but there was no finding or declaration based upon those objections that those qualified as unethical fitting. A declaration of that. Now the board has set the bar, and the argument or the position that the Gilliams took at the meeting or hearing, because evidence was taken and evidence was presented, that they looked at the veterinarian report and there was no declaration of unethical fitting, only injections and some swelling or edema, which would be consistent with normal injections. The board likes to talk about irritants, and because there's a specific provision about irritants, I want to address that just for a second, is that the veterinarian said that he had no idea what substance, if any, was injected, and he had no evidence of irritant. And there are natural medicines such as vitamins, B12, penicillin, another item that was mentioned at the hearing, that are natural and will not show up on a drug test.
Counsel, if the standard is there has to be a declaration by the veterinarian, then what does the review process look like there? Is the review process solely looking at the veterinary report? Can the committee and the board take into account the fact that, for example, at least one interpretation of the record is that the Gilliams changed their position as to whether they had any idea whether these injections had been made from one meeting to the next? I mean, can the board take that into consideration?
Two answers. Because it's on a spectrum of time. First of all, I believe that the board can look at the underlying, if the procedural or standards were met, if there was an ultimate declaration by the veterinarian, the board can look at the facts that would underlie that declaration. No doubt, they could look at the fact that there were injections, or in another case, there was drugs, or whatever the case might be, to test the conclusion or to confirm the conclusion. I think that would be a process that they could go through. But again, having set the bar as a declaration And all contestants are going to rely upon that. They have to be, I think, held to that standard. Now, if you conclude otherwise, and that the mere existence of injections under these circumstances is sufficient declaration by the veterinarian, then the board's decision is just proper within its regulation. We may disagree with the facts, but the scope of review would support it. So again, to frame this very fairly, and not to lead us astray on any other issue, that is the crux. That is the crux, the absence of a declaration, because Justice Walker had a good question on Ms. McClaskey. I think that as fairness and to protect the integrity of the process, as the board has argued, and just fair due process fairness, that requires that if you're going to recuse himself, then you're not sitting as a judge and you're free to comment on evidence, and you start providing what is essentially expert testimony based upon, with the preface that, hey, I'm not an expert. I think that's a due process problem, or it injects improper facts into the process.
Counsel, your clients were present during that discussion, right?
Yes.
Okay.
Yeah.
Thanks.
And I'm sorry, I neglected the second part of your question about the subsequent evidence that was presented when the board met to basically, I think it's pretty much the same makeup, the joint committee and the board as a whole. Having heard the discussion and the testimony and the comments, obviously the Gilliams went back and said, we still have no idea. They went back and talked to the group of people that were involved in assisting in the care of the lamb prior to September 10th, and discovered that, hey, vitamin B12 was administered to the lamb that could have indicated or been the cause of the injection sites. They didn't know that until they went back and got additional information.
Now, counsel, that's certainly evidence they could have presented at the hearing, though, right? I mean, they knew going into the hearing that this was one of the two main issues in dispute, whether or not someone had injected the lambs, correct?
Could they have gone back and talked to those people? Of course they could have.
And they could have brought them in as witnesses.
Obviously they could.
And they could have also requested independent testing of the carcass themselves and brought in their own veterinarian to testify about the findings at the hearing. They had that ability.
They did not have that ability. The carcass had been destroyed at that point in time. And again, let's take back their argument. And if Jerry Gilliam, Gabryelle's father, said, in looking at the report, it just says injection sites. There's nothing that says it was unethical fitting. There was no drug testing. Tell me where in the rules injection sites only under these circumstances amounts to unethical fitting without the declaration by the vet. Yes, at lay people looking at the information, if I was advising them at that time, I would say, have you done an investigation as to anybody who touched that lamb? Because at the time, they didn't know. They didn't know, and they were operating under the assumption that there had not been prior injections prior to the 9th when the animal arrived at the fair that would have been within the rules. They didn't know that they were focused again on what happened when the lamb was delivered to the fair on the 9th. And keep in mind that as of the 10th, my clients had no access to the animal. And so they had to say that they're somehow responsible for something that might have happened after the board should have taken possession of the lamb and kept it secure and not allow people or other participants to have access to it. They have no idea what may or may not have happened. And so again, that also, I think, mitigates the fact that they may not have been Johnny on the spot in January, when the joint meeting took place, to marshal all of this other circumstantial evidence that I don't think became apparent until the decision was handed down.
Quick question, and I can't remember if I ever knew. Did the veterinarian appear at the joint committee hearing, or just was a written report just presented?
The veterinarian prepared, there's an email, there's an affidavit, and he appeared.
Was
And
he ever asked the question by anyone? In your opinion, was this unethical fitting? I mean, it seems like we've danced around whether he said it or shouldn't have said. Did anybody ever ask that question of him when they had the opportunity to? Or did he just decline to opine on that?
he was not asked that question, and it was absent in his report. And when you look at it as a whole and look at the emails and the email that's in the record, in fairness to the board, his affidavit and the testimony that there's a transcript, he declined to say basically anything other than there were injection sites in the hindquarters. There was some swelling or edema in the muscle, and it's been characterized as substantial. I may be wrong, but in preparing, I find nothing that talks about substantial. Everything was, this is the reaction of injections. He could not identify when they were administered, but he said he thought it would be within the 7-day period from the 13th back in time. And he had no evidence of there was no testimony as to irritant or any substance. And he said, I'm not speculating further. And you could tell, I think, at least from my view, you look at his testimony in the transcript, you could see that he doesn't want to go farther than he can go. And so Ms. Stanky or nobody from the board said, "Is this? Do you declare this to be unethical fitting?" Even though that's the standard set forth in the citation or the order of disqualification.
Or nobody asked, "Is this consistent with unethical fitting?"
The word in the questions that were asked the vet, and I looked at it last night to make sure that I had a good memory. I don't believe that the term unethical fitting was stated by the vet, or it was in the form of a question to the vet.
Are these proceedings under oath, by the way?
I do not know. I cannot remember. I cannot remember. I do not believe. I do recall that there probably wasn't any oath of the Gilliams. I can't remember whether or not there was an oath to the vet, but he did submit an affidavit that I believe would have been under oath.
Any other questions from the panel? All right, Council, it looks like your time is up, but if you want to take a couple of seconds and wrap up, I will allow you to do that.
Yes, and flag me when my time is up, Judge Warner. I appreciate it. Going back to the jurisdictional requirement, a couple things. The case law on point says that the identification of the agency employee or representative for service or for the delivery of any appeal or service has to be in the order. The decisions are, it doesn't render it not a final order, but it tolls. It tolls the period. If you look at the amendment that the board relies upon that talks about substantial compliance with service of process, and this is in 77-621. No, I'm sorry. That's the wrong statute. I'm sorry. 77-614. Subparagraph E on substantial compliance. It's in terms of what happens when the appeal is filed, and it uses the term service of process. And in wrapping up, service of process would be a term of art, not used in KSA 77-613. And service of process, and there's a very similar rule in Chapter 60. That relates to service of process. Service of process is the service of a document that gives notice that a proceeding has been initiated, and the governing body, the court, is taking jurisdiction over you. Service of process is different than service of paper or anything that would have preceded the filing of a petition. And again, 614 puts that in context. It's also important in my final
Counsel, I think that your time is up.
I appreciate it. I
Right.
appreciate it. And thank you for your patience with me, to all the panel.
Certainly. Ms. Willoughby?
Thank you, Your Honor. To follow up on some of the things that were said and Judge Klein's observation that, yes, the Gilliams had the opportunity and the burden at the joint committee meeting to present any evidence that would overcome the disqualification finding on both grounds. And these same people that they're saying they later discovered gave the shots were people they got a statement from on the DNA ground. So there's no reason why, if they had this argument and it was an argument they wanted to pursue, they couldn't have presented that at the joint meeting. The meeting was really intended as an opportunity for the Gilliams to present their point of view. It wasn't sworn, no one was under oath. The veterinarian wasn't even supposed to appear. If you look at the record, it was Jackie McClaskey asked him to come in there. So he came in without preparation and to basically answer any questions that the Gilliams wanted to place to him. And that's what he did. He wasn't asked that question by the Gilliams. Well, where is the evidence of unethical fitting in your report, doctor? I will disagree with counsel's characterization of those findings. And it's stated in our brief, in the reply brief, and with citations to the record, that he did find evidence of irritation or an irritant or injection site reactions, which granted, for the sake of those of us who aren't doctors, it would have been awfully nice if he would have put this in more lay terms, but in the reports, but he did not. But he did make those findings. In terms of the whether the Gilliams knew what was on the table, but prior to the joint committee meeting, they'd gotten a letter from Susan Sankey stating the grounds for disqualification, including the rules. They'd gotten the vet report, which they said they were not disputing. They said that several times. They got, Sankey asked them several times to tell them what had happened. That was 2 or 3 times off the record. She asked him, send me anything explanation you got, and they never did. And so when they showed up at the meeting, that was their opportunity. And it was just very argumentative. And you can kind of get that sense from the transcript, but if you listen to the audio, you really will. In terms of the people who talked at the meeting, it wasn't just Jackie McClaskey. A lot of the people, the board members, opined on their experience showing animals and what these findings of the vet might meant. And this failure of this particular phrase to be used by the veterinarian that's been relied upon so heavily, yes, that phrase is in Susan Sankey's letter, but it's not in the joint committee's findings, which by the time we get the joint committee's findings were more controlling at that point than Susan Sankey's letter. So that issue, which is not a good issue, but it was basically wiped out by the joint committee's finding. In terms of what counsel was reading from, where that language is contained in the rules under consequences, he didn't read the last line of that, which states the Kansas State Fair Board, through its management, makes all rules and regulations and reserves the final and absolute right to interpret these rules and regulations. So there it says it's management's decision. That's also under the section on interpretation. That's also in the code of conduct. So 3 times it's basically stated that the fair, through its management, is going to interpret these things. And
so if that's the case, I agree that that's what the rules say. But if that's the case, why does the rule also say that after a veterinarian has declared, or once a veterinarian declares that an animal has been unethically fitted, then the animal is disqualified?
Well, it says whether it's a veterinarian or the testing agency, I do believe it's probably not the best choice of words. We all agree on that, but the idea, because it causes confusion, but I think what they meant to say, if there's a factual basis for it or an expert basis for it, Because it's the same thing. The testing results just come in with a positive. The testing agency, and it's an expert agency, doesn't say, oh, we declare this land unethically fitted. They just say what they found. Now, the other thing about that rule, the language of it, why it's in there, and I don't really know, but it talks about the animal being disqualified or the competitor from all future events. So there's a broader consequence here that wasn't imposed on the Gilliams, but could have been. Why it's stated in those terms, I don't really know. It's not fortunate, but in terms of the reading the rules as a whole, it's kind of clear that, and it makes sense that the managers are the ones that get to interpret these rules. I see my time is up.
I have a question kind of based upon your broad sweep of authority, the board, and I agree that it reads that way. But if the definition of an ethical fitting is dependent by the board's own rules of a veterinarian making a finding of an ethical fitting, is the board free to disregard its own rule when it makes that requirement?
Well, I think where I disagree with you, sir, is that an unethical fitting, there are definitions of it that also don't say that a veterinarian has to find it. It just says these are the acts that constitute unethical fitting. So it doesn't say who declares it. And that's also true in the code of conduct, which talks about what acts are deemed unethical fitting. So nowhere in the substantive rule does it say that a veterinarian has to declare it.
Oh,
so
okay, well, I'll reread them.
So this is super technical reading, which is also true on the KJRA aspect, but the idea that someone can sit around for months having notice of agency action and not seeking review is just contrary to everything else in the KJRA, which is let's get on with it. Let's file our petitions in 30 days and get on with it. So I see my time is up. If there are no further questions, let's see if there are.
Any other questions from the panel? All right, if you'd like to take 10 seconds and wrap up, Council.
Thank you. Thank you, Your Honors. On behalf of the Kansas State Fair, we would respectfully request that the decision to disqualify Gabryelle Gilliam's 2016 State Fair entry be affirmed by this court and the district court decision reversed. Thank you.
Thank you. Thank you, both counsel, for your arguments today, as well as your excellent briefing on this matter. We will take the matter under advisement and get our opinion out as soon as we're able.